My name is Mary Edenfield. I'm a partner in Dinsmore's Orlando office, and I practice in Dinsmore's healthcare practice group. And my co-presenter, Dan, will introduce himself in a few minutes. But we want to get right into our agenda because we do think we have a lot to get to today. So, what we're talking about is licensure portability, what it is, what we mean by that, and the significance of it. And talk a little bit about what some challenges have been historically to portability of licenses and some recent developments that may help out in some of those challenges. And then maybe do a little prognostication about the future of licensure portability. And we are going to try to leave time at the end for some questions, but if you have any questions, put them in the chat when you think of them, and we may be able to address them at the time. So let's get going. By licensure portability, what we're talking about is the ability to use one's qualifications for licensure in one state or actual licensure in one state to apply for licensure in another state. And the reason this is significant is healthcare provider licenses are state specific. They're issued by an individual state, and they only allow a provider to practice in that state. So to practice in any other state, a healthcare provider will have to become licensed in the other state. So it's important to note that the practice of medicine or other profession occurs where the patient is located. So historically, if a physician treats a patient, the physician should be licensed in the state where the patient is. And that's become, of course, real significant recently with telehealth. But basically, we have a little example here that's not real far-fetched. If an Ohio provider has an encounter via telehealth with an Ohio patient who happens to be at Disney World in Orlando, that would be considered practicing law in Florida because that's where the patient is. So, Dan, next slide. There are some of the obvious ones are if somebody relocates, moves to another state. Sometimes people relocate temporarily, but if they're going to work in the state where they've relocated, they're going to have to be licensed in that state. And possibly someone is a part-time resident in the state. We have something in Florida that we call snowbirds that come down here for about half the year. And it's possible that someone who did that would be able to find a situation where they could practice, but they would have to be licensed. And then you have a lot of situations where you have borders with other states where someone may have kind of a cross-border practice and be licensed in more than one state. And we've also had situations come up where someone located elsewhere wants to have a satellite office here. And, maybe that's preparatory to relocating or retiring to Florida or something like that. But for whatever reason, they've got an office in, say, Ohio and an office in Florida, and they would need to be licensed here to do any work here. And also telehealth, like we mentioned before, the practice is where the patient is. So if you're conducting telehealth, you need to be licensed where that patient is. And a couple other things I didn't put on the slide that occurred to me later is the proliferation in locum tenens physicians who kind of move from place to place, and similarly nurse travelers. And those people need to be licensed in the states where they are practicing.
All right. Thanks, Mary. I think it's my turn to go here. And yes, my name's Dan Zinsmaster. I'm a partner in a healthcare group at our firm as well. And I'm here in the Columbus, Ohio office. Prior to coming to Dinsmore a number of years ago, I was a medical board attorney. So um, this this slide up here dovetails a little bit with my prior experiences. Why do states care? Why do the agencies within those states care if a physician or other type of healthcare provider is entering into their jurisdiction to practice, either on an isolated or more persistent basis? And there's a lot of reasons why they care, and they're all self-interest for those states, wanting to know and what's transpiring on their, proverbial turf, for lack of a better way of putting it. If a person or business is doing any sort of commerce, any sort of operations in their jurisdictions, certainly the state has a vested interest in making sure that what is being done, what is transpired, is being done appropriately and is being done safely. So again, establishing those standards, minimal thresholds that must be met in order to operate, they want to make sure that that's being adhered to. Of course, if that doesn't happen, if there is an issue, then there is error, harm, or otherwise. The states are going to want to make sure there's accountability for that, and that, liability, being able to serve legal documents, whether they're complaints and lawsuits and actions or whatever, but certainly wanting to make sure that people are accountable for what they do in their jurisdiction. And so all those things are connected. And then, of course, if it's a service or aspect that has some sort of it's subject to taxation, certainly the state is going to want to collect those monies. And so that's another interest that drives these sort of turf battles, these implications that states have with, wanting to know who's doing what in my state, in my backyard, and are you accountable for it, and are you following all the legal obligations that come along with that. So a lot of these interests, self-interests by states, have over the years, over the decades really, created barriers to license portability. And again, they're largely constructed or largely a result of these states developing independent rules and regulations from each other. They're not doing this in unison. They're not doing it all at the same time. They're all doing it piecemeal on their own in the way that they see fit, based upon their implications, their understandings, and their values. And so that can lead to inconsistency and confusion within these systems because they are different from one another. And that can cause also enhanced costs, which can add up, not just for, say, filing different application fees, but if you're an applicant, you want to pursue a license or a professional endeavor in another state, might not just be simply fees that must be paid for. You've got advisors that you might need to enlist to help you set up an endeavor in another state. And so those are costs as well. It's different across agency to agency, state to state. But again, trying to get insight about what you need to do to get a license, to get a certificate, a permit, or whatever. Sometimes you'll run into unresponsive agencies. They might not be willing to offer insight, or they might be just slow to respond, and all that can, again, frustrate the process, create delays, create burdens and barriers, and lead to frustration, confusion, fear of the unknown, and that all is counterproductive with people, again, moving from state to state to practice or to set up operations. Why do these barriers exist? Again, as Mary just said, the practice of any profession generally is dictated by state law. So what's permissible in Ohio might be different from Michigan, which might be different from Montana, which might be different from Florida. Certainly there's going to be similarities, but there's also going to be differences depending on, again, those values and the systems that were set up. So again, as we heard earlier, the standard of care or the standards for licensure, they are state specific. And when a state agency is looking at admitting a professional to their roles, granting them a license, they're wanting to see if this licensed professional over here are they qualified, or do they have the substantial equivalent to the qualifications that are generally required in their state? And you can get variation, between state to state. For example, some states, if you're seeking a full license, they might require you have 1 year of residency training. Some may require 2 years of residency training. So a person might only have 1 year. They could get a license in one state, but now they want to move to Ohio, for example, where we require 2 years of residency training for a full license. And at least generally, if you're a foreign graduate, for example, and then you run into a problem where you apply your license in one state, you think that's going to be fine in Ohio, and then you learn otherwise. And that can lead to some problems. Again, if you don't meet the qualifications in a state after you've applied, not only are you running into these delays and roadblocks, and maybe you've wasted some fees on applications, but it can also lead to more persisting problems, such as, again, if your license application gets denied, even if that denial is a non-disciplinary type, it's still something that the individual might have to report on future applications for licensing and credentialing, which can trigger future scrutiny, which can trigger further delays down the road. So again, it's important for providers to understand what the rules are, the expectations are before they're submitting applications. It's important for advisors to, again, understand those before they're telling somebody, oh yeah, go apply there, and then they apply there, and then a can of worms is opened up. So these are important issues to be aware of. Again, other barriers, again, like we just heard, you might, the unwitting doctor who engages in the telehealth encounter with their existing patient, what they didn't know at the time of that encounter is that they weren't in, they, instead of being in Columbus, they were on vacation at Disney World in Orlando. And now you've just practiced in the state of Florida. And if you don't have a Florida license and some other exception doesn't apply, again, you can run yourself into some serious trouble. Not only, again, an administrative issue, potential license discipline, or some sort of issue with that. You might, if there was a claim submitted to a healthcare program, again, that might be a false claim, because if it wasn't done in the appropriate course of professional practice, it's a false claim. Now you're looking at civil monetary penalties and a variety of other ramifications. Then on top of that, unlicensed practice generally is a felony in each state. So again, by unwittingly engaging in practice in a state without a license, you can trigger a whole host of problems, a whole host of issues, and that can have some serious ramifications for that individual, whether they, did it intentionally or unwittingly. And altogether, again, these barriers, they lead to, again, a loss of opportunity and income for the provider. So you're affecting that side negatively, and you're limiting the accessibility of quality specialists and care providers to patients. The bigger the market, the more physicians to choose from, generally the higher the quality over time, and again, greater access to especially specialists that might be hard to reach. And so again, if telemedicine or other things can open these doors, or avenues can be created for folks to reach these providers, it helps the provider, it helps the patient. So again, trying to lower these barriers has been a significant issue for many years now. COVID, not a lot of good things came from COVID, but there was one that I like to note, and that was the proliferation of telemedicine. When we were all in lockdowns and can't go anywhere, and people still had healthcare needs. Telemedicine had been around before that, obviously, but I mean, it exploded in terms of interest, in terms of acceptance by the public, and then not only that, people coming to use it, people coming to understand it, people being willing to leverage it as a modality to reach their provider and get care. But the states realized they're in a bind. They got to allow some flexibility so that, again, people can engage in this type of practice and occasionally allow it to go across state lines. So that was already in play in some states before the pandemic, but the pandemic really brought that to bear even more so. And again, here I've got a note here about Florida. I believe Mary's going to talk about that particular license later on, but Florida had, I guess, gotten a head start on the pandemic, with telemedicine licenses and special registrations, even before the pandemic hit. Again, other influences that we're seeing as far as motivations to lower these barriers, create more flexibility. Again, there's a lot of private equity investment in healthcare. That's causing practices to grow, to innovate, and to expand. And not only the PE investment side of things, but medical systems. Now, instead of being an Ohio only system, now they're crossing jurisdictions. You have hospital systems in Cincinnati that have a footprint in Indiana and Kentucky in the tri-state area right there. So again, with a provider working for that system might be motivated for their providers to have multiple state licenses. Same things with other states and other cities as well. So again, these are all implications that are cause for lowering these barriers and expanding opportunity. And with that, you're seeing it become easier with these doors being open, with this enhanced flexibility. And so there are different options. There are different qualification requirements from state to state, but what we're seeing is more streamlined processes. And so Mary's going to talk about the first one here, which is licensure by endorsement.
Yes. So licensure by endorsement is one of the ways a licensed provider might be able to use their licensure in one state to kind of help with getting licensed in another state. And we're all probably more familiar with licensure by examination, which is probably the most common pathway for licensure, but licensure by endorsement is an alternative to licensure by examination in Florida. Probably other states have similar provisions. So by licensure by endorsement, we're really talking about an expedited process. It would allow a provider to become licensed in a different state from their original license based on having substantially equivalent license. This is, again, like all of licensure regulations, state specific. But in Florida, go ahead. We had some recent development. We had in 2024, a new law was enacted called the Mobile Opportunity by Interstate Licensure Endorsement Act, or the Mobile Act. And that citation is not quite right. But anyway, historically in Florida, some professions have provisions for licensure by endorsement, but many others did not. And so this Mobile Act created uniform requirements for licensure by endorsement for all healthcare professions. And so for those that already did allow licensure by endorsement, it changed their requirements to comply with the Mobile Act. And for those that didn't have that option, it's created that option. So, and I listed just some of the professions, but as you can see previously, MDs could get licensed by endorsement, but DOs could not. So that's all changed. Everybody's going to be able to get licensed by endorsement. Now, I found some information that's not totally up to the second, but as of January 6th, and keep in mind this law went into effect last July, as of January 6, 2025, the Department of Health had received 3,263 mobile apps or applications and had issued 769 licenses. So this was evidently pretty popular. And there were 951 applications pending. 176 of those didn't qualify because they didn't meet the practice requirement, which we'll talk about in a minute. And the remaining ones that were pending of the 951 are pending documentation. And they did comment that if someone does not qualify, that they're allowing them to withdraw their application rather than be denied. So that goes back to something that Dan was saying about you really don't want to have a denial on record. So the requirements for the Mobile Act, and again, these apply to all the professions. First of all, the active unencumbered license from another state, District of Columbia, or territory of the United States. And obviously it has to be in a profession with similar scope of practice. And the statute defines scope of practice as the full spectrum of functions, procedures, actions, and services that the practitioner is allowed to practice under their license in Florida. And that is as determined by the applicable professional board. And one note here in Florida, and it's probably the same in other states, but most of the healthcare professions here have their own professional practice board, like the Board of Medicine, the Board of Nursing, and so forth. But there are some that don't have a board, and in those cases, the Department of Health, which is kind of the umbrella department, kind of functions as a board for those. So in a lot of these requirements, you'll see, it's determined by the board or by the Department of Health. Okay, on with the requirements. Passing score on a national licensure examination or a national certification recognized by the applicable board, the Department of Health. And for those professions that don't have a requirement for a national exam or a national certification, the board or the Department of Health would have to make a determination that the jurisdiction of current licensure meets the minimum education requirements and any applicable examination, work experience, and clinical supervision requirements must be substantially similar to the requirements of Florida. So again, they're looking for equivalency. Okay. Now, this next requirement is interesting. The requirement is that the individual must have actively practiced the profession for at least 3 years during the 4-year period immediately preceding the date of submission of the application. And I didn't look at every profession, but that's a change from what the Board of Medicine used to require. And interestingly, there is a bill pending in the Florida legislature, which is currently in session, that would change this to 2 years during the 4-year period immediately preceding the date of submission of the application. So that legislation has passed the House and is pending in the Senate, but there are 3 days left in the legislative session, so I was going to make it. But anyway, that's something that may turn out to change. Also, the applicant must not have had disciplinary action in the 5 years immediately preceding the date of submission and must not currently be the subject of a disciplinary proceeding in any jurisdiction where they're licensed or by the Department of Defense for reasons related to the practice of medicine. So, more requirements, if required by the specific profession, the applicant has to meet the applicable financial responsibility requirements. That's your malpractice coverage or an acceptable alternative. And I listed the professions that have financial responsibility requirements. And then the applicant has to submit fingerprints for background screening. And those listed are the professions that require the background screening. And then certain professions require a person to be listed on a Department of Health website profile. And so they have to include all the information required for the profile. And then if required by the profession, they can be required to complete a jurisdictional, or I think it's a jurisprudence examination, anyway, an examination specific to the state laws and rules regulating the profession. Now, there are some things that will render a person ineligible for licensure by endorsement. And those would be a complaint, allegation, or investigation pending in another state, the District of Columbia, or a territory of the U.S., conviction or a plea of no contest to a felony or a misdemeanor related to the practice of healthcare profession, having had a healthcare provider license revoked or suspended in any other state or DC or U.S. territory, or having voluntarily surrendered a license in lieu of disciplinary action. And then this was an interesting provision, but any report to the National Practitioner Data Bank would exclude somebody from licensure by endorsement unless the applicant had successfully appealed to have them removed from the data bank. And I was surprised there wasn't any more controversy about passing this, because that's cast a pretty wide net. There are a lot of reasons people could be in the data bank. But this bill that I mentioned that's pending would change this requirement and would give the applicable board or the Department of Health, where there's no board, the ability to exercise discretion with respect to a national practitioner data bank report if the data bank report is for something that does not violate any Florida statute or regulation. So if that is the case, under this pending legislation, the board or department would be able to either approve the application outright, even though there's a data bank report, or could approve with a restriction or approve with the requirements, such as getting treatment or CLE or CME requirement, or could deny. But I think that would be an improvement to the statute. Again, we got 3 days left in the session, so I don't know if it's going to happen this time. And I also wanted to, remind you that this is ineligibility for licensure by endorsement. It's not necessarily ineligibility for licensure. So even if somebody doesn't qualify for licensure by endorsement, they can apply another route. They may have to explain, these complaints or support the database, but it's not an automatic ineligibility. So I'm going to kick it back to Dan and talk about some other options.
Thank you. And yes, again, beyond licensure by endorsement, there are other avenues. Obviously, there is always the tried and true regular licensure by examination method, but now we're seeing some other enhancements in recent years, and one of those, will probably maybe the most prominent that we hear about, is interstate compacts. Again, remember earlier when I talked about inconsistent systems and processes serving as a barrier to license portability. The response or the method to try to fix that or eradicate that barrier, or at least lessen it, is through interstate compacts. These are formal agreements between 2 or more states to harmonize their regulations or their systems, so that, amongst the participating states of that compact, if you're qualified in this state that's a compact member, you're going to be qualified in the other states as well that are also participating in that compact, and that enhances portability significantly. Now, that's not a one-stop shop as far as those that are participating in the compact, because participating state boards still do retain their licensing and disciplinary authority. So again, oftentimes you can add to it, or again, if there's something that a licensing board believes would be a violation of their Medical Practices Act, and they can pursue that. But again, as we are seeing, this has been kind of sweeping the nation. We're going to talk about a few of them here in a second, but we've seen them in medicine, nursing, and a whole lot of other different types of professions, that healthcare professions. So again, this is happening quite a bit these days. The way it works is that to participate in a compact, provider first needs to register with the compact governing body or commission. They go out, they fill out some application materials and some other information, submit that to the compact or body or commission. then through that compact, they then select the states that they are interested in becoming licensed in. Could be one, or it could be two or three, could be a lot. Depends on obviously the field and the profession. If you're emergency medicine provider that does some locums work, maybe you kind of hop around to 3, 4, 5 states. If you're a radiologist, you might read states in almost all of the states, or read slides in almost all the states. So then you would want a whole bunch of licenses. So again, this is an avenue to try to facilitate acquiring a lot of licenses. But of course, there are fees, and the fee structure can vary from compact to compact. But generally speaking, it involves a standard fee to the commission to register with the compact, and then additional fees depending on the states you want to practice in. So, kind of add those up, over time. You might, if you're trying to get licensed through the compact in 4 states, you might have 4 additional fees in addition to the compact fee. If you're looking at 14 or 24 states, now you got a lot of individual fees to assess on top of that. But again, this is to facilitate that and make it a lot easier as far as gaining licensure. So let's turn to medicine. The Interstate Medical License Compact currently has 37 states as members, plus Washington, D.C., which has its own licensing board, as well as the territory of Guam. Although, and this was something that caught me off guard, and I was unaware of until working on this presentation, Michigan is in the process of withdrawing from the compact. They are currently a member, but starting March of this year, they've begun the process to unwind that. It's a 12-month process to leave the compact. And so by March 28th, 2026, Michigan will no longer be a compact member. Also, there are some states that are not states of principal licensure. That includes Connecticut, Hawaii, Pennsylvania, and Vermont. This means you can get a license issued for these states through the compact when you qualify through another state of principal licensure. I'm going to talk about really what that term of art means in a second here in the next slide. But again, those 4 states can't serve as your SPL. Some states, Arkansas and Rhode Island, have passed legislation to join the compact, but there are process delays with joining it. Once you've passed the legislation, then the rules, administrative rules, have to get put into place to then facilitate the actual procedures and workings that would be attended with this process. And so after you have these legislation, or obviously all these states that are participating or have already passed legislation. Several have legislation pending to join. That includes Massachusetts, North Carolina, New Mexico, and New York. And then there are several holdouts with no legislation pending or other intent indicated that they want to join. That includes Alaska, California, Oregon, South Carolina, Virginia, Puerto Rico, and the U.S. Virgin Islands. And so just a second ago, I did mention state of principal licensure. Think of that like home base. That is your state that becomes the epicenter for all the other compact state licenses that you get. And every physician that does the Interstate Medical License Compact has to have a state of principal licensure, SPL. And so there are criteria for which state can serve as that for the physician leveraging this opportunity. It has to be the state where they are, and at least one of these. It doesn't have to be all, just one of these to qualify as the SPL. Either their primary residence is in that state, or a quarter of their practice occurs in that state, or their employer is located in that state, or that is the state of residence for the purposes of federal income tax purposes. So any one of those can be the basis for picking your SPL, but you have to have an SPL. And if you are, say, one of those states that does not allow your home state to be the SPL, like let's say you're a physician in Pennsylvania, but you want to leverage the Interstate Medical License Compact, and you're going to have to find another one of these categories in another state to have that state, be it Ohio, perhaps, be your SPL, because Ohio is an SPL state or an eligible SPL state. And again, if you want to change that designation at some point, that's okay. There's a redesignation process that you go through. And again, just show those criteria would be applicable to a new state and change that designation. Special note to anybody who practices in Michigan or is from Michigan, when Michigan withdraws from the compact, if you use Michigan as your SPL, that will go away. And that means all of your other compact licenses would be compromised as well. So make sure before the end of March of 2026, you switch your SPL from Michigan, if that's what it is, to another state that has that status available. You don't want to see some sort of domino effect where you lose Michigan as that status and then all your other compact licenses get compromised as a result of that. There, like everything else, there are eligibility requirements, and it's easier just to talk about what you can't have in place in order to be eligible for a compact license. That includes a history of disciplinary action against one or more of your medical licenses. You cannot have a criminal history, and you cannot have a history of controlled substance actions, stuff with the DEA, or if you're a state that has a controlled substance license in addition to a medical license, again, that license or that certificate can't be compromised. And on top of that, if you are currently under investigation, even something that's silly and frivolous and certainly not going to go anywhere in the disciplinary process, but under investigation nonetheless, you are disqualified at that point in time or not eligible for the Interstate Medical License Compact. So if pursuing this or if advising somebody who's interested in pursuing this, make sure they have a clean background. Again, it's not to say they wouldn't be otherwise eligible for a license the old-fashioned traditional way, where a state can really, weigh out the merits and their approaches to that background and their scheme. But here for the Interstate Medical License Compact, it basically needs to be a clean license, clean background in order to proceed to go. Please note that when using the Interstate Medical License Compact, you don't just get one license. Like I said, it's licenses for each state that you select. You go through the compact, you pay your fee to that commission, and then you designate which states you want to get licensed in, and then you're getting each of those individual state licenses. So again, that's going to be the initial application fee to the commission of $700. And then if you also want to be licensed in Ohio and Florida and Pennsylvania and other, right, Georgia, again, you're going to have to pay additional licensing fees on top of that. And again, those states will be the one to issue you the license through this process. This process just streamlines everything significantly. So that's medicine. What about nurses? Well, there are two different compacts for nurses. One is the Nurse Licensure Compact that is pertinent to RNs and LPNs only. And then there is an APRN compact for advanced practice registered nurses, or just more commonly called nurse practitioners. But each of those there's those two compacts that exist. And again, for those participating states, it allows for an easier route to get licensed in those jurisdictions. The Nurse License Compact is up to 43 jurisdictions that are currently participating, applying for this multi-state license. It works a bit different than the medical one. This one is done through state nursing boards. RNs who live in a compact state and meet these uniform licensure requirements are eligible. And here are some of those criteria, similar to what we saw for doctors. You have to have a home state and meet the eligibility requirement for that home state because you're applying through that home state. That license needs to be active and unencumbered. No prior felonies or misdemeanors related to the practice of nursing. And importantly here, because I've run into this before, the nurse can't be a participant in an alternative program. That's something for impairment related to either substance use disorders, mental health, or physical illnesses and other conditions of that nature. Those programs are generally confidential and non-disciplinary, oftentimes through practitioner health programs. And that, by participating in that, you avoid license discipline. So again, they don't have this license discipline, but they are being monitored. And by virtue of that monitoring through the alternative programs in each state, that would make that nurse ineligible while participating in the monitoring program. Again, then they would just have to go through the regular traditional licensure methods. Or if they are licensed through the compact, and while they have those compact licenses, then enters into an alternative program, they might need to take steps to kind of disconnect the license from the compact so that they can maintain those licenses, because otherwise they are ineligible due to not meeting the criteria. The APRN compact is a lot smaller in terms of participation than the nurse license compact. We only see a handful of states that are participating, some with legislation. Those are, the dark blue are the ones that are participating. I believe there's just 4. And then there's a handful of others that are considering joining at this time. I think that's probably due to a lot of variation between the qualifications that go into being a nurse practitioner or CRNA. It can vary in terms of clinical hours and experience expected in order to maintain that higher level of certificate. On top of that, you have issues with autonomy. Some physician extenders, nurse extenders can have significant autonomy, and others are certainly a more subservient, collaborative role to their physicians that they engage in supervision with. So again, it's something that's not as robust in terms of the amount of states participating, but certainly I believe over time we will see that continue to grow. And so in addition to medicine and nurses, there are others out there. We have audiologists and speech and language pathologists. You have OT professionals, physical therapists, psychologists, emergency medicine services, and EMT providers, and a whole host of others. There's a good 10, 12, 15 compacts around with varying levels of participation. So if you're not a doctor or a nurse, that doesn't mean this avenue isn't something available to you. Do some research. Chances are there is a compact out there, and it might be something that you can leverage in terms to expand your practice, expand your ability to move from state to state and engage in that professional activity. Outside of compacts, what else is out there that allows for license and practice portability? Well, I'm going to talk to you about some Ohio exceptions, because that's obviously where I'm from and where I practice. But one of them is the consultation exception under Ohio law. The statute's there on your screen. And there is an exception in Ohio. So for a physician who is not licensed here, who provides consultation to an Ohio patient, or for an Ohio patient to an Ohio physician, they will not engage in unlicensed practice, or they would fall within this exception if, again, they meet one of these criteria we see here. It's not something done with regularity or frequency, although I will note that those terms are undefined and ambiguous. So again, there is some risk there from the provider standpoint about, am I doing this too frequent or not? Is this becoming a regular habit or not? If there's no compensation provided, that's an influential factor that can lead to it falling within the exception. Or is this consultation part of the curriculum for a medical, an academic medical center or medical school? That can allow for, again, this exception to apply. And I think, Mary, you've got some information here about Florida and how they handle consultations. So can you comment on that, please?
Florida has a similar exception to the definition of practice of medicine. It doesn't apply to a physician lawfully licensed in another state or territory or foreign country. when meeting a duly licensed Florida physician in consultation. And there are some regulations that kind of flush that out. The consultant physician is permitted to examine a patient, take a history and physical, review lab tests and x-rays, and make recommendations to the Florida physician with regard to diagnosis and treatment. But the consultant physician cannot perform any medical procedure on the patient or actually render treatment. And this is in the regulations, but the DO regulations have some similar.
All right. Thank you, Mary. So back to me again. Let me say a few words. Ohio has a contiguous state exception packed into our statutes. Again, the codes are there for you and your own review. But physicians who are licensed, they have to be licensed in another state or the state bordering Ohio, whose practice might extend into Ohio, meaning they might be on the border in, say, Indiana or Kentucky. An Ohio patient goes down to see them in Kentucky or crosses the border into Indiana to get care, then goes back home. There are some exceptions that can allow for that physician to communicate or provide some level of follow-up care, even if the patient's still here in Ohio. Again, we heard earlier, the practice of medicine occurs where the patient's located. Patient comes to you in Fort Wayne, Indiana, goes back home to Defiance, Ohio, calls you up, says, hey, I'm having a side effect from the medication you prescribed. What do you think? Again, you can leverage this exception so that you are not engaging in unlicensed practice. So again, importance, significance, understand the exceptions when you may or may not need a license, because otherwise the default is you're practicing medicine, you don't have a license, you're engaging in wrongful conduct and impropriety. But there are some exceptions that exist for that type of infrequent contact or something where, again, a patient traverses state lines, goes back home, but it's something that stems from what you've already done. And Ohio law, for example, is okay with that. They facilitate the permission to do that in certain circumstances if you meet these criteria. But as a provider or an advisor provider, make sure you understand, because again, you don't want to get tripped up. And just because Ohio has that doesn't mean everybody else has that. You have to know what takes place, the laws of your state, if you're going to be able to, again, exercise that type of authority. Some other special licenses, some states have stuff for public health emergencies. Georgia has a special emergency practice permit that allows the governor down there to allow for enhanced licenses in situations involving states of emergency and other disasters. We saw tons of that, obviously, during COVID-19. But, whereas Georgia has something like this on the books all the time, most of the other states that did that relative to COVID-19, they had that and it's gone away. So those were largely temporary in nature, and most have since lapsed. A couple other special licenses that I want to mention. Ohio actually has an expedited licensure service that not many people know about, where for a much higher application fee, $1,000 versus a shade over $300, you essentially can get the board staff to serve as your concierge to assist you with getting certain documents needed for licensing, and to usher you through the process with much greater ease, and to turn around that license application and hopefully get it granted much, much faster, much quicker turnaround. Typical turnaround for licensing in Ohio is anywhere from 4 to 8 weeks, can be more depending on if there's disclosures in the application. This opportunity definitely streamlines that significantly. But again, there are higher eligibility requirements, much like you saw with the compacts and licensure by endorsement. Essentially, what you need to do this is a clean background. Otherwise, they're going to need to scrutinize, and therefore these more efficient, effective routes are not going to be available to the provider. Some other, again, license types that of note, we have special activity certificates, charity volunteer licenses, clinical research certificates, all unique. And again, if you're a physician who wants to go do something briefly, maybe you don't need a full license to do that. Maybe you're only going to be there for 30 days or less. The special activity license would suffice for something like that. Maybe you just want to go perform charity care. Again, there is a volunteer certificate. It's only valid for 3 years, but again, lesser and different requirements for that, and not something that requires the full scrutiny of going through and getting a full license. Or if you're affiliated with, again, clinical research, there's a clinical research certificate as well for those who are associated usually with hospitals and academic medical centers to do that type of work. And Mary, can you tell us a little bit about these special licenses in Florida, please?
Yeah, and I'm just going to go real fast because there are a bunch of slides, and these are all applicable specifically to MDs. DOs have some of these, but not all of them. But basically, medical faculty certificate, a temporary certificate for area of critical need, a limited license that's kind of basically for someone that currently is retired. Go on to the next slide. Yeah. The visiting faculty at the medical schools or affiliated clinical facilities, so that would be like a residency program. All of these are temporary, based on, you have to be licensed in another state, but you get a temporary certificate or registration in Florida. Next slide. I want to just go real fast. This is the visiting physician cancer center, kind of specific. It's for somebody who's training. And then the other visiting physician is for somebody who's teaching. So 2 different visiting type things. Public health certificate, you can only practice really under employment with the Department of Health. I wanted to get to this out-of-state telehealth because there's a question. And the question is, if there's a current trend about developing telehealth only licenses. And I don't know about a trend, but we mentioned this briefly earlier. In Florida, there's the telehealth registration, and it applies to. It's not limited to physicians; it applies to other professions as well. So they just have to register. The big thing is they can't. If you're registered as this, you cannot practice in the state physically. You can't provide care in the state physically or open an office. If you did that, you would have to change that registration to a practice. And do you have any feeling about whether there's a...
Well, actually, interestingly, Ohio used to have a telemedicine license, and it operated the same way. It was for physicians only, but they got rid of it. Let's say about 5 to 8 years ago by now. But it was the same thing. You had to be a provider outside of Ohio. You could not have a physical office in Ohio to be able to leverage that particular certificate. They just got rid of it and consolidated all of those regs into their full license and said, we just want to have, you either qualify for the full license or you don't. And where you do that, we don't care. You're either, if you're out of state, serving Ohio patients via telemedicine, still need the full license, or, or if you want to pick up and, move to Ohio and again, practice here in a brick and mortar office, great, whatever works. But that's, at any given time, and I speak a lot on telemedicine issues. I know over the course of the last 10 to 15 years, there's been any number of, 5 to 10 of those states and boards that have those special licenses. And even, and remember too, to our audience, I would note, there's 50 states plus our territories and whatnot, but there are a lot more licensing boards. For example, Florida, as Mary would note, you got an MD board and you got a DO board. Ohio, we're just one. but you have to know that what might be the pathway for licensing and practice for one type of physician in this state could have some material difference for the other side, for the osteopaths, as opposed to the allopaths. So it is something that, some states do still have them. It would not surprise me if the proliferation of compacts causes those to become somewhat obsolete. But, a lot of those compacts are, again, they're profession specific. And your telehealth, in Florida, registration certificate or whatever we're calling that, that's for all healthcare providers. So, I mean, you have the ability to do a lot more through that. So, again, if you're maybe not a doctor, but, a different type of ancillary provider, and you want to be able to provide services, that's an opportunity to, again, expand in another state. So what do we see in the future? What potential things? Again, maybe full and complete adoption of the interstate compacts, or at least more robust participation. Continued expansion of licensure by endorsement, I think, is certainly, we're going to see a lot of that, and other forms of reciprocity. Will we ever get to the level of being a uniform, language and expectations? Licensing boards are overseen by, peers of that profession. And oftentimes those are strong-minded individuals, and they have strong opinions. And so you're trying to get, a group of strong-minded physician leaders in one state to agree with a similar body in another state. It's easier said than done. But, over time, again, we are seeing this expansion. We are seeing more portability, and that's a good thing, both to providers and to patients. And that's the big takeaway here, is it's easier to do this than it was years ago. And that's a positive for everyone on all sides of this issue. So we have reached, I think, the end of our time. Autumn, is there any questions?
The one that was in there has already been answered.
All right. Well, I guess with that, we would certainly want to thank our audience for their time and attention, and allowing us to speak with you today. Should you have any questions, our contact information is available, and Mary and I, at your convenience, would be happy to discuss any of these issues with you now or in the future. And we thank you for your time. Hope you have a great day, and our very best to you. Take care.